Yeah. Good afternoon, friends. Thank you for coming for this public lecture. My name is Chow Ying, and I'm the convener of Projek-SAMA, Project Stability and Accountability for Malaysia. Today, we are honored to have Dr. Venkat Iyer together with all of us here to talk about one very important topic and very timely discussions, which is appointment of top judges, comparisons of several common law jurisdictions. Now, there has been a lot of discussion lately about how Malaysia appoints its Chief Justice and senior judges. It's natural to ask, are there a better and fairer ways elsewhere? Projek-SAMA is pleased to have Dr. Venkat Iyer, a barrister and constitutional lawyer in Northern Ireland, to join us as he shares how several other common law jurisdictions manage their judicial appointments and what lesson we can draw to make our own system more transparent, accountable, and merit-based. This is a timely conversation in our nation's continuous struggle to strengthen our judicial independence. So let me just very briefly introduce Professor Venkat. Professor Venkat is a barrister and academic based in Northern Ireland. He is attached to the School of Law at Ulster University, being the Director of Educational Partnerships and International Affairs. He teaches media law, constitutional law, business law. He has been in legal practice since 1981 and is, among others, a trained mediator as well. Between 2008 to 2015, Dr. Venkat served as a law commissioner for Northern Ireland. He's an expert in various areas. Constitutional law is one of it. Highly informed on international and comparative perspective. And that's the reason he's here today to talk to us about other common law jurisdictions, how do they appoint top judges. He is also visiting professor in many universities, including University Malaya in Malaysia. He is acted as a consultant for a number of government and private corporations, non-government organizations as well. So let us give the next 40 to 45 minutes of our time to Dr. Venkat.
Can I stand here and talk?
Yes.
Yeah. Okay. Just click this on you. Oh yeah. Okay. All right. I need to have both. Yes. Okay. All right. So thank you, friends, and I'm overwhelmed by the introduction that has just been given of me. I don't think it deserves quite as much build up as was given, but thank you again, and thank you all for coming. I will keep my presentation, as it were, to about 40 minutes, as was mentioned. And I want to talk essentially about the mode of appointment of judges, which I think is a focus of the afternoon. There is a significant variety of judicial appointments in even just within the Commonwealth, let alone outside the Commonwealth. And I can't obviously cover all the countries, but I thought I'll just trace some of the trends that exist within the Commonwealth, and particularly the bigger jurisdictions of the Commonwealth. Now, I'm assuming that all of us accept the importance of judicial independence. But I would say judicial independence, important though it is, has also to be seen alongside judicial accountability. Because without uh, accountability, independence alone is not going to um, uh, serve the purpose that we expect the administration of justice to serve. I might even actually be slightly bolder and suggest that if you look carefully at this in this area, you'll probably agree with me that judicial independence, judicial accountability, etc., are probably more important than even democracy, which is not a plea against democracy. Let me stress this. So, why am I saying this? I'm saying this because, in the way that democracy is normally defined and understood, one person, one vote, the ability of people to choose their own lawyer, their own representatives, etc. Um, it is quite possible uh, that you may have a system of government where that element is lacking, but if it is compensated for by a non-corrupt, uh, competent judicial system, some of the uh, lacunae um, in government can be um, can be avoided, at least can be remedied. Now, the best example I can give of the proposition I've just outlined is Hong Kong before its handover to Chinese rule. If you remember, and it's a little difficult for us because this happened quite some time ago, Hong Kong had no democracy in the way that we define it at the time the British handed over Hong Kong to China. No democracy, not even local government. But Hong Kong enjoyed a very high level of judicial independence and a very good system of justice administration. Not surprisingly, therefore, alongside Singapore, Hong Kong had a high level of confidence from the business community. As you know, there were so many multinational corporations which had their regional headquarters in Hong Kong without actually doing much business there, manufacturing, etc. Now, why did they do that? Business people, I think, vote with their feet. They will not go to jurisdictions where enforcement of contracts is a major problem, or more generally, there is a problem with getting justice. Hong Kong had also a lot of other attributes: free press, um, a great degree of affluence, other freedoms before Chinese rule. So it was, for all practical purposes, like a Western country, like a free Western country without democracy. So, and yet, the colony, of course, it was a colony, there's no denying that, uh, worked so well. I'm not remotely suggesting, therefore, that we should go to that model in any of the other of the existing countries. All I'm trying to tell you is I want to underline the importance of the judiciary. And there were so many arbitration agreements in that region which had Hong Kong as the either the seat of arbitration or as the applicable law. Now, all that is a show of confidence in the judicial administration of the place. So, I would say, therefore, that uh, an independent judiciary is very important. But I would add that it's not enough to have judicial independence. You also need to have other things, including judicial competence. Now, if you don't have competent judges, sensible judges, then formal independence of judiciary is no good. And the best example I can give of that is India. India has actually quite an independent judiciary. But if you look at it from the point of competence, it is down there. I'm sorry to say this, but it's a reality. Okay. Not to mention, of course, as a result, other problems arising, such as corruption, in a big way. Um, and that has, of course, impacted the system very significantly. A civil suit in most Indian cities takes a minimum of 29 years to get resolved, and this is not counting the appeals. So, what point is? I mean, what use is a judiciary which may be formally independent, but which does not deliver the goods? So, again, the reality is actually more complex than we imagine. There is no magic wand for the administration of justice, but there are certain things we need to keep an eye on. And I would say, therefore, that um, when we talk about appointment of judges, many of these things also have to be factored in. Um, Quite clearly, of course, the level of confidence that the public has in a judiciary is very, very important. And that comes, first of all, with time, but also with a demonstrable proof of fitness for purpose of the judiciary. Um, Not to mention, of course, the importance of resources. A country may again have uh, a good judiciary on paper, but if it's not properly resourced, what use is it? That's another way of killing a judiciary, by saying, we have incorruptible judges, we don't interfere with our judges, and yet you starve the judiciary of resources, and the result is that the administration of justice fails. Okay, these are just by way of introductory remarks. Now, let me come straight to the nub of the matter. And here, I think I have to start with a truth which is slightly uncomfortable in many jurisdictions. And that is that uh, no judiciary in a modern system can be completely independent of the executive. It is just not possible. And to a lesser extent, also the legislature. Because, for a start, a judiciary needs funding for its survival. And where does the funding come from? It comes mainly from the executive, but also from the legislature, because somebody has to legislate for the funding. It's true, of course, that in most countries, the money is debited to the consolidated fund. But even so, who organizes the level of funding? It has to be the executive, the elected government. Um, and you could make a distinction between institutional independence and operational independence. In other words, the judiciary might be institutionally independent, but what about in its operations? That's another level of independence that we need to talk about. And the most common dangers are, of course, political interference, nepotism, corruption, undue pressure from members of the judiciary themselves. That also happens in many jurisdictions. Uh, and also, sadly, judicial grandstanding that also can significantly diminish the effectiveness of a uh, judiciary at an extreme level, which fortunately most of us don't experience, but which is not entirely unheard of. There is state capture of the judiciary. Now, these are all realities we cannot ignore. And so I'm keeping this talk at a general level. I'm not addressing the Malaysian situation. Please keep that in mind. Um, and as I've already said, judicial accountability is another aspect which needs to be borne in mind. And when it comes to judicial appointments, I think as part of what I just mentioned, it would be utopian and unrealistic to expect the executive to have no say in judicial appointments. So that's a starting point. It's sort of a baseline point I'm making. And then I'll build on this and say how uh, improvements can be made to reduce the extent of executive interference. Um, because not only does the executive pay the judge's salary and other emoluments, um, they also actually need to ensure judicial accountability, for example, to the public. Most of the time via Parliament. That's how the accountability mechanism works. Um, and don't forget also that if a party that becomes a ruling party in any country in a fair election, that's of course an important caveat, if that party made certain commitments in its election manifesto about the judiciary, which parties do from time to time, then, and on the basis of which they were elected, then I think it has both a right and a duty to contribute to the selection process in the judiciary and to ensure a smooth delivery of those commitments. Now, you could argue that they could do this without tinkering with appointments, etc. But I think it would be unrealistic. And you could also, at a higher level, think about executive contribution to judicial appointments as part of the checks and balances in a democracy, because you don't want the judiciary to become a law unto itself. And I say this because there's currently a phenomenon in the world's largest democracy, India, where judges have become uncontrollable in the sense of, it's only jurisdiction, only democracy that I know of where judges select other judges, which is very unsatisfactory. Even if you had good people, the whole idea of not allowing anyone else to have a say in the selection of judges, I think, is wrong in any country. So one needs to guard against that as well. The challenge really is, therefore, to reduce or to eliminate unacceptable interference in appointments. Now, of course, I've used a word there which itself can be debated, which is what is unacceptable interference. And essentially, we're talking about the injection of political or party political considerations or nepotism in the selection of judges. Sometimes it is argued that one way of reducing executive involvement would be to allow a degree of legislative involvement. And then you come to the American kind of system where there are confirmation hearings. I personally am not in favor of that at all. Apart from it being a situation of washing dirty linen in public, there is also the possibility of an erosion of public faith in the judiciary, because in a sense you question a judge before he's appointed about his views. Now you could argue, okay, he can change his views after he's appointed, I agree, but at the end of the day you get a sense of what the man is and what his values are, etc. At that stage it's not a good thing, and people will make a pitch to please the legislators to ensure that they are selected, they're appointed. Now, are there any Commonwealth trends? Yes and no. I mean, in broad terms, there are, which I'll talk about. But I would say that even within the Commonwealth, there's a wide variety of models being used for the selection of judges. And as always, some are more effective than others. If you're talking about external factors, they also play a small role, at least in the judicial processes. For example, what is the level of litigiousness in a country? That also, I think, matters in terms of selection of judges. Also, are there reasonable controls on avoidable litigation? A very good example in that regard is the increasing emphasis on ADR, in particular mediation. It is not inconceivable that in a few years' time, mediation will become mandatory, at least in some kinds of litigation. There are certain kinds of litigation where you can't make it mandatory. So let's then look at a few of these models. So the traditional Westminster model, which has dominated selection processes in many countries, would involve a minister of the crown. Typically in England, it's a Lord Chancellor, or it could be in other countries like Australia, the Attorney General, who would have the dominant say. And the traditional model relied on a method which most people nowadays would consider anachronistic, which is through a system of soundings. So, if you wanted to appoint somebody, there would be what is called, nowadays pejoratively called, a tap on the shoulder. So, you would be approached by the Lord Chancellor's people and told that there is uh, a wish that they would accept a judgeship. And what do they think? Uh, but it is not quite as crude as you think it is. Now, again, don't think I'm advocating this for all countries. I'm just trying to tell you that it is not something to be dismissed out of hand. Uh, Preceding the tap on the shoulder, there is a lot of consultation that happens. There are so many people who are canvassed for their views about potential candidates, starting with judges who see counsel appear before them regularly. And of course, this is premised on the basis that almost all judges are selected will be from the bar. That is not uh, to be taken for granted today, because now you have people from diverse backgrounds coming to the judiciary. But by and large, when the system operates, I'm just trying to describe to you how it worked. There would be a lot of soundings taken. And the one thing I would say, maybe slightly controversial to all of you, is that if you think that getting a potential judge's CV uh, examined, vetted, you're going to get a lot of information about him or her, I would say you're mistaken, because a CV will tell you a lot about a person. The one thing it will not be able to tell you is a person's character. Qualifications, yes, absolutely. I went to Harvard, I did this, I did that. Character, that you can only get by talking to people who know them. And so, therefore, I personally, I'm willing to stake my neck out on this. I'm a great votary of that system, whereby, as long as there is no overt bias, and I agree that there can be some possibilities of bias, but as long as that doesn't happen, the bar is a place where people get to know each other extremely well. And if you consult the right people, they'll tell you what a person's defects are, what his strengths are, etc. And I would say, at least as far as the UK is concerned, the old system at that time, we're talking about 30 years ago, worked reasonably well, because even though the Lord Chancellor was responsible, the Lord Chancellor had this unique position of belonging to all three branches of government. So he was a member of the cabinet, he was the presiding officer of the upper house, the House of Lords, and he was also a judge who actually used to sit on cases. Nowadays, he doesn't. Actually, nowadays we don't. We have the peculiar position of the Lord Chancellor not even being a judge, not even being a lawyer. Um, so the Lord Chancellor actually was in a unique position to be able to get this, what nowadays is called a 360-degree view. And the one thing that did not happen, even at the worst of times, was there to be overtly party political appointments. Any Lord Chancellor, whether Labour or Conservative, would never appoint someone because the person supported the party. That never happened. Now, it is an accident, you can call it that, but that was the result. Anyway, so that was the traditional model. Then you had a variation in that model in newly independent countries. So we are talking about the 60s, 70s, etc. And the first model was of a small judicial service commission, a small one, completely different from what exists today as judicial service commissions. And it would normally be chaired by the chief justice of the jurisdiction, and a majority of the members of the judicial service commission would be judges. So it was largely a judicial body that that determined who is going to be chosen. Now, this Judicial Service Commission also, to a large extent, relied on the tap on the shoulder method. In other words, it is a commission, but it's a commission which approached individuals and said, "Would you like to be a judge?" etc., etc. But of course, this model didn't last very long, because there were pressures saying, ultimately, you're perpetuating the same system. The single biggest criticism was, uh, you're all part of the same fraternity. Now, you cannot get to a bigger pool of candidates. That was the single biggest criticism of this. And therefore, many of these small judicial service commissions were wound up. And unfortunately, in some parts of the Commonwealth, these commissions began slowly getting infiltrated by politics. Now, that is a very unhealthy development. This happened particularly in some of the African countries. Um, and of course, in Africa, various other things happened. For example, the advent of dictatorships, etc. So that paid put to all these processes. Then you had what I would call a second wave of commissions. Now, these were different from the judicial service commissions I described earlier. Most of these were statutory or constitutional. Many of the constitutions actually described the nature of the appointments process and also the commissions. And actually, now, as we speak, I would say about 80% of Commonwealth countries have these kinds of commissions, so statutory or constitutional. Um, but in spite of that, even today, appointments to the highest court are not determined by these commissions, by and large. Okay, so I believe there was some sort of a survey carried out by, I think, an academic body, and it said something like appointments to the highest court are still in the hands of the executive in a significant minority of states, 27%, and in 50% of the states, the chief justice chosen by the chief justice is chosen by the executive. So executive control is still quite dominant in spite of the spread of these commissions. And of course, in 21% of the countries, apparently, parliamentary confirmation is required. Not in the way it happens in America, but some sort of inquiries, etc. And since the 1980s, there is also a broadening of the base of the commissions themselves. So, what is called more inclusive membership, which means you have members from various levels of the court system, practicing lawyers, and significantly, lay members. Now, this is slightly controversial. So, what you have are people who may have no legal background being quite significant in the selection of judges. It has a good side, it has a bad side. I'm simply telling you what the situation is with these kinds of new style judicial service commissions. But of course, what many of the people who devised these commissions did was to ensure that no constituency had a majority in the selection of judges. So there's no question of capture by one side or the other. And in a few countries, something more controversial happened, and that is the introduction of a quota system, particularly countries like South Africa, for understandable reasons. But I personally would think introducing a quota system for judges, basically reservation of seats for judges, is a very dangerous thing to do. My own feeling is merit has to be the only criterion. I know the arguments against it will say, oh, in a country which has been suffering so much oppression or discrimination, what do you mean by merit? But I'll say that it is still worth considering merit as a sole criterion. And over time, the effects of long-term discrimination will go away. But okay, that's a purely personal view. So, for example, if you were to look at the South African situation, the majority of the members of the commission would be executive nominees or MPs. Then there are teachers of law, practicing lawyers, and also civil service representatives, etc. So these are I think mostly called JACs, Judicial Appointments Commission, which is a term I think familiar to all of you in Malaysia. And the JACs themselves have become very structured and very sometimes rigid in their composition. So they have fixed terms, they have oaths of office, code of conduct for their members, and there are also open competitions for membership of the JAC itself. So you can see there'll be some sort of a notice put out, and people are asked to apply. And now the difficulty is that these kinds of competitions encourage pushy people uh, to get in, and sometimes slightly more shy but substantial people may not even apply. So keep that in mind. Again, I'm just giving you the pros and cons. Um, and in a couple of countries, Kenya and South Africa, they hold interviews which are open to the public. Now, this I think can be a very serious deterrent to many candidates who want to go on the JSC, not to become judges, to go on the JSCs. Um, so that is what is happening currently. Um, Now, something else has also happened. There are lots of complaints over the selection processes for JSC members, which has generated a cottage industry of um, adjudication. So there's an ombudsman to oversee in England and Wales complaints from people who are not selected to become members of the JSC. So that has spun another a sort of round of litigation, or not litigation, at least complaints. So there's a lot of friction, you could even call fractiousness, etc. So, what I've just described is broadly what exists in a majority of Commonwealth countries. Now, we come to Indian exceptionalism. India, as you know, is the largest Commonwealth country. So, in India, a peculiar thing has happened. The Constitution of India actually prescribes the method of selection of judges. The Constitution goes back to shortly after independence. So 1950 is when the Constitution came into force. The Constitution is quite clear in the way a judge, I'm talking about judges of the higher courts, okay, not lower judiciary, have to be selected. So the Constitution vests the power to appoint judges formally in the president, which would be the equivalent of your king. So it's purely ceremonial role. Obviously, the president is not going to be personally involved in selecting judges. What it means is that it is the executive which will effectively choose the judges, and the executive will have to consult the chief justice. That's a requirement, constitutional requirement. Now, you could argue that if the chief justice himself is, shall we say, dodgy, then executive consultation doesn't mean much. But I think that would be a bit too cynical, because by and large, chief justices, at least for the first many years, were doing a good job of recommending correct candidates. Because remember, the executive does not have a database of candidates. They will have to be, the names will have to come from the chief justice, and then they'll discuss and eventually pass the names on to the president. And the chief justice in turn would consult his senior colleagues before recommending names. So indirectly, there was a more collegiate system of recommending names to the executive. And ultimately, of course, the executive would pass on the names to the president to be formal, for the president to formally appoint these judges. Now, what happened in 2014 or thereabouts was that these constitutional provisions, I'm sort of cutting short the actual process for lack of time. The process was turned on its head. And now this is impossible to justify. You ask me a question, how did it happen? I cannot reasonably give you an answer. The Supreme Court, in 3 cases, called the first judge's case, second judge's case, and third judge's case, unimaginatively, came up with a solution under which it was the judges who would recommend names and to the executive. So the opposite of what was contemplated in the Constitution. The constitutional provisions have not been amended. They still remain what they are, but the process has been turned upside down. And so the judges recommend the names to the executive. The executive have one chance to reject a name, or not reject, ask the judges to reconsider the names. If the judges say, no, we are still keen that this person should be appointed, the executive have no choice except to appoint that person, which I think is very bad. Now, because this system was seen as unsustainable or unacceptable, an effort was made by Parliament to pass a law called the National Judicial Appointments Commission. And when that law was passed, unsurprisingly, it was immediately challenged in the Supreme Court. In India, almost everything goes for a legal challenge. And they also have this pernicious doctrine, which started as a good doctrine called the basic structure doctrine, under which if the Supreme Court says entirely on its own reckoning that something is against the basic structure, then it is beyond tinkering or beyond change. So the National Judicial Appointments Commission was struck down, the law was struck down, and system went back to what it was, judges appointing judges. So under the NJAC, the way it was meant to function was that the NJAC would consist of the Chief Justice and two senior judges, the Minister of Justice, and two eminent persons within inverted commas, which in turn, these two people will be selected by a committee consisting of the Prime Minister, the Leader of the Opposition, and the Chief Justice. So indirectly as well, you could see that the Chief Justice had a disproportionate power or influence in the selecting of the committee and therefore the judges. But all that was shot down. So ultimately, all that happens now is judges select other judges, and it has led to a lot of not only heartburn but also injustices, and there's so much politicking happening there. What about the UK? Another leading member of the Commonwealth. So since 2001, judges are selected by a JAC, Judicial Appointments Commission. The role of the Lord Chancellor has been very severely reduced, and the JAC itself is a very widely based body, including lay members, etc., etc. The discretion that the Lord Chancellor enjoyed is very significantly reduced. High Court judges are appointed on the recommendation of the JAC. The most senior judges, including the Lord Chancellor, the Master of the Rolls, and the heads of the three divisions of the High Court, as well as Lords Justices of Appeal, they are all appointed on the recommendation of selection panels appointed by the JAC. For the Supreme Court, it is by advertisement. Now that also is debatable. So the government puts out an advertisement from people of 10 years standing or more at the bar, and solicitors as well. And there's a process, interview process, etc., etc. Now, this also has the disadvantage of some people not wanting to get into that kind of a competition. If I'm, seen as not performing well at an interview, even if I'm otherwise qualified, I don't want the embarrassment of applying and not getting the job. This happened a few times. There's a lot of heartburn in terms of people being superseded. There might have been a very good judge who has served for 20 or 25 years up to the Court of Appeal level, and he is passed over by somebody from the bar who at least he feels is less meritorious. But anyway, there is a lot of subjectivity. There's no doubt about that. Australia, the formal appointment is done by the Governor General, who is like the equivalent of the President or the Queen or King. And of course, the Governor General acts on the advice of the Prime Minister and his cabinet. Australia has a system where the executive clearly has a say. Okay, there is no JAC and all that. So the Attorney General, he makes a recommendation. Actually, the AG there has a very significant amount of power. He makes recommendations to the government on future appointments, and he is, of course, if it's a High Court appointment, which is the equivalent of the Supreme Court. As you know, the High Court is the highest court in Australia. Then the AG is also required to consult the AGs of the various states. So there's that federal requirement, if you like. So I would say, for all practical purposes, there the appointment is executive. But the AG is, of course, a member of the executive. Canada, again, largely through the executive. The Chief Justice of the Supreme Court is appointed by the Governor General, again acting on the advice of the Prime Minister and the Cabinet. The Supreme Court has 9 seats. Now, there in Canada, there's a quota system, as you can imagine, particularly to placate Quebec. So, and there are also requirements, there are language requirements. So everybody has to be fluent in both French and and English. So what are the criteria? Ability to resolve difficult issues with wisdom, fairness, and compassion. There's formal criteria for judges. Energy and discipline to diligently study materials. Ability to retain an open mind and consider all of the material. Patience and courtesy. Ability to write well-written and well-reasoned opinions. And ability to work cooperatively with their colleagues. And as I said, also functionally bilingual, French and English. So a short list of 3 to 5 per vacancy would be submitted to the Prime Minister, and the Prime Minister would decide whom to appoint from that short list. So that is a kind of system that Canada follows. You're probably more familiar with what happens in Singapore, where also there is no JAC as far as I know. So I will leave Singapore for the time being. I also realize I've actually exceeded my time, so I'll just wrap up by saying that I mean, there's no doubt that individual judicial values affect the outcomes in many sensitive or borderline cases. So judicial appointments, how judges appointed is extremely important, particularly appointments to the final national courts. And I don't think, on the basis of what I've seen, that there's any single perfect model of appointments. Clearly, there's also some room for prevailing conditions within a country. The levels of public morality, willingness of politicians to exercise self-restraint, very important, and show tolerance of divergent viewpoints, not just formal diversity in terms of so many blacks, so many browns, so many Muslims. You know, that sort of formal quota system is probably not going to be very helpful. So, you know, it is possible actually to look at models elsewhere and try to emulate the good parts of those models. And of course, eternal vigilance is another very important thing, public vigilance, and which is why in a lot of countries you find that the writings of people in the media actually do help in deflecting politicians from unwise decisions sometimes. But I come back to a point I made at the beginning, which is that to avoid executive involvement in judicial appointments is, I think, unrealistic. We have to accept that. All you can do is try to temper the involvement of the executive with some norms that most people would consider reasonable. I think I'll stop there. I've spoken for too long, and I'm more than happy to engage in a discussion. Thank you. Yeah. Where do you want me to sit there? Yeah. Okay. All right.
Let me swap it.
Oh, I see. Okay.
The battery away.
I see. Okay. All right. Thank you.
Perhaps you could
In the middle.
sit here.
Okay.
Shall we?
Yes.
Right. Right. Sorry.
So thank you, Dr. Venkat, for just a very overview. But I think you drive home the point that there's really no, the baseline is we cannot totally eliminate executive in the appointment process. Of course, we would like to open the floor for any Q&A. But I think maybe I will start first.
Sure.
So Malaysia, I think we have the model of having a JAC.
Yep.
The JAC will, there are many criticisms of JAC. I think there's improvement to that. For example, the compositions that you're talking about. But I think the reason controversy really points to one question as whether the JAC recommendations has to be accepted by
the government.
By the government, right?
Yeah.
And if there is any rejections, how should we make it more accountable and transparent?
Yeah.
Because I understand that under the constitutions, it is the Prime Minister advise the YDPA appoints.
Yeah.
So the question is, we cannot totally take away the Prime Minister's role under the constitution. After all, he is an elected from the people, but because he is elected, he has to be accountable. He has to be transparent. So how do we make sure that an oversight mechanism to ensure that even there is a rejections, it has to be explained. Is it good to have explanations to the public? How do we tighten that part of it?
You see that, sorry, is it on? Oh, okay. Is it working? I'm not sure. Can you hear me?
Yes.
All right. Okay. So you see that, of course, is a central challenge. Now, let us look at the best case scenario. Suppose there is a good candidate who has been rejected. A preliminary point that arises is who judges who is good, okay? Because even amongst if you like, a short list of 3 people, there'll be some who will argue that X is not the best candidate. X is not even a good candidate. Can be, but put that to one side. Let us assume that there is one person who sort of gets universal acclaim for being competent, sensible, non-corruptible, all the qualities you want in a judge. Now, if that person is rejected, you're quite right that there must be some sort of explanation. Now, the difficulty is, can a public explanation, first of all, will any prime minister, any member of the executive be candid enough? Most probably they won't. There will be a bland press note put if there's a legal requirement for reasoning to be given. Okay, and these things are not justiciable in most countries. It is very difficult to go by way of JR and say, let the Prime Minister's office defend its choice of judge or rejection of a judge. So there will be a bland statement. And normally the statement will run along the lines of, the Prime Minister has considered all the qualities and he is of the view that difficult though it has been for him to arrive at a decision, that Y rather than X is in the circumstances the most qualified person or something like that. It is impossible to get from someone the real reason. And of course, in most cases we know of such bias, the real reason lies elsewhere and it will never be disclosed. So, honestly, much as I completely agree with you in terms of the sentiments you express, to translate into legal provisions is not easy and it might be probably impossible, because no executive law minister or prime minister is ever going to say that. So what are the alternatives then? Clearly, public vigilance is very, very important. And it is not impossible actually for judicial appointments to at least some extent be influenced by public pressure. But I'm also not against public pressure per se, because it can go in the opposite direction. Not necessarily in countries like Malaysia, but there are certain other places where a populist person may actually, it's almost like saying, I run a campaign to become a judge and I will mobilize public opinion in favor of me being promoted as a possible judge. The populist judge phenomenon is a dangerous one as well. So there are just so many things involved. So I honestly don't have an answer as such.
I guess this is really a difficult one, because I think at the end of the day, the Prime Minister will have to be accountable and answerable to the people in the next general elections, perhaps, right?
Correct.
But of course, I still hope that there are some kind of mechanisms for us to at least voice this thing. So I think in the last EGM that called by the Bar Council, one of the resolution put forth by one lawyers is to make the minutes of the JAC open. I'm not sure whether you feel.
No, I'll tell you what happened. We have actually a living example of that, so I can speak from experience. Again, going back to the unsatisfactory but prevailing experience in India. What happens is, this body, sadly consisting only of judges, the equivalent of the JAC, but with membership only drawn from the judiciary, has a legal duty to publish the minutes of its meetings. And it is supposed to be, it is available on the website of the This body is incidentally called a collegium. Okay, that's the name by which it goes. It's not a commission, it's a collegium, and the collegium keeps shifting, or its composition changes. It is for federal appointments to Supreme Court. The collegium consists of the Chief Justice and 5 other judges, 5 senior most judges. For the state high courts, the Chief Justice appointment will consist of the Chief Justice and 3 senior judges. So you know the composition of the committee in advance. Now what they do is, because they're obliged to publish the minutes of their meeting, the minutes are drafted so blandly that there will be nothing of substance in the minutes. It'll say the collegium has convened on such and such day. There'll be 2 or 3 paragraphs totally irrelevant about the collegium's convening. We had a cup of coffee, we did this, that, and the other. And then to say, of the candidates that we scrutinized, very careful consideration was given to each one of them, including the qualifications. There's that, and another 2 or 3 paragraphs of absolute rubbish. And then finally to say it was unavoidable that the matter had to be resolved. We only have 1 vacancy, and we had 3 candidates or whatever. So we chose the best person. Now, this is not the Prime Minister speaking. This is a body of judges saying they're as bland as you can expect to be. And internally, we know that the meetings were not half as straightforward as was as was reflected in the minutes. And sometimes you also get to know, because the bar is a wonderfully informative, and that there were fireworks within the committee. The tragedy is, each judge in the collegium had a favorite whom they would promote. And sometimes they win, sometimes they don't. And sometimes a case of swaps. Okay, if you promote this man now, the next time a vacancy arises, we'll promote your man. Very, very sad. So it's unsatisfactory.
Any questions from the floor? Is there any question from the floor?
Chinwat.
Yeah, Chinwat.
Do you want a mic? Yeah.
Oh, okay.
You need to wear that as well.
Thanks. Thanks for your enlightening lecture, and also the entertaining example of how the Prime Minister's statement could be completely meaningless. I think eventually it comes down to one point, that all systems are basically imperfect. It's which imperfections that suit us at this particular time. That circumstance may change. Ultimately, in the case of Malaysia, I think if we go for the elected one, whether it's the executive, the majority of the elected political class, or parliament, so that would be bipartisan or multi-partisan, or in the case if you let the judge, the church themselves, it's almost like Catholic Church. And then finally we have the palaces. So which one do we go? That's one big question. I think in the case of America, that this is split between the
possible in Malaysia, because your total number of parliamentarians is quite small, isn't it? What is it?
222. But
Right,
I
even
mean,
that is quite large. But in countries like the UK, virtually impossible. 645.
600.
Yeah. So okay, let us assume what will then happen is you will have a committee of parliament. Now, of course, if there is any fairness, the committee will have composition proportional to the strength of the parties in parliament. But inevitably, the ruling party will be the largest. Okay. Now, to what extent whipping happens, formally or informally, also determines. Even if there's no whipping, but suppose a signal is sent by the Prime Minister, look, we want to avoid X on the Supreme Court, then the majority of members are going to be hostile towards this person. The second important consideration, even if they're not, suppose it's a very transparent, not transparent, it's a very fair process. The second question is, should the questioning happen in public or not? And I would be completely against it happening in the public. In other words, a televised debate. Because if you want to really question a person whom you want to appoint as judge, you're going to ask questions which the person will be very uncomfortable to answer, even if they have nothing to hide. it all depends. You know,
Yeah.
some terrible things come out in the public hearings in America, and there, of course, the system is different because it's presidential, not parliamentary. So I don't know about the merits of a public hearing. It is possible to have a closed door hearing and assume that members of parliament will do their job properly. Possible.
Yeah. Okay. Thank you. Any other questions?
I think one of the frustrations that we really have is that we know all this thing happening. It's just that there's really nothing we can like. There's nothing we can
Do about
it
Yeah,
and push
yeah.
about it. And the next question that I think maybe also relevant is that internationally in other country, what about the background of the judges upon, I mean, the judges that is being nominated in terms of their political background? You know, is there a criteria? Is there a yes or no or what? Because I think Malaysia, the latest Chief Justice that were appointed has a political background. He was a member of parliament before in a, you know. So what is your view on that?
Okay, sorry. Yeah. Yeah.
I'll speak loud so that you don't have to
Yeah.
use the mic.
Yeah.
I think there is in this particular judicial crisis, there's a concern that someone can be picked, despite his junior position, to be made first Attorney General, then promoted to the High Court, and then the Court of Appeal, all the way straight to be the Chief Justice. So question here twofold. One is the questions to avoid such circumstance. Second is the larger questions of whether, a more general question, whether there is a fundamental conflict of interest for someone from the prosecution. So in this case, is combined with the political appointment of Attorney General to be appointed to the higher courts. Should there be a cooling off period? Thank you.
Between being Attorney General and being appointed on the bench.
Yes.
Yeah.
Yeah.
Okay, that is a question which also has another dimension. It is not uncommon or even unfair for an Attorney General to be appointed a judge, though the Malaysian experience points in the other direction. I don't have to name the person involved, but there was definitely at least one appointment which showed that that is not at all desirable. But Singapore has a reverse phenomenon of a judge becoming Attorney General. To me, that is very, very dangerous. You know, you were a judge until yesterday, and today you come and argue at the bar. You know, not at all good. So put that to one side. That is not going to happen. That is hopefully not going to happen in Malaysia. But going back on the merits of it, a cooling off period, probably not. Now, undoubtedly, the Attorney General will have a predisposition, unless he's very, very independent, to be supportive of the government. Some of them are more than supportive. They are beholden to the government. There is a major problem there. So it is difficult. Now, I forgot to mention one thing which also is very relevant. You know, in parts of South Asia in particular, and of course the preeminent country in this regard, as always, is India. So India, Pakistan, what they do is they select only for the post of Chief Justice of the country, the Chief Justice of Supreme Court. They select on the basis only of seniority. Only of the seniority. If you're already a judge in that court, in the Supreme Court, for example, if you had the system in Malaysia, federal court, all federal court judges will be considered, and the person who is most senior will be appointed Chief Justice. No questions asked about the person's competence or anything else. That has been followed in India continuously in an unbroken tradition since 1977. And the reason for that was Mrs. Indira Gandhi, in a brazen show of partiality, allowed for 3 + 2, 5 independent judges to be superseded within inverted commas. the expectation was that a senior person will be appointed. Now that also I think is a very wrong principle, although it's a neat principle. So there is no question of anybody accusing the Prime Minister of interfering. But the difficulty with that is very incompetent people become Chief Justice. And what is worse, you have this ridiculous phenomenon in India sometimes because of seniority. A judge is made Chief Justice for 1 month, or there was a very absurd case of a fellow being Chief Justice for 3 days. And there's going to be one very soon who will be Chief Justice for 1 week. And she's going to be the first female Chief Justice. And it's actually at one level so embarrassing to listen to her. So there are 2 more people in the queue before she becomes Chief Justice, but she knows exactly on what date she's going to become Chief Justice on the basis of seniority. So she, in public speeches, at least I've heard one speech where she says, if God is willing, or if nothing happens to me, I will have the great distinction of being the first female Chief Justice of India, almost sort of bragging about it. Now, and she's only going to be Chief Justice for 1 week, okay? Now, that is unsatisfactory as well, even if she's competent. I'm not talking about the woman, anybody else. Be a Chief Justice for 3 days, on what criterion? So that is another principle which also should not be allowed in the name of eliminating these other problems to prevail.
Is there any questions from the floor? Or anyone from the online that is asking questions?
No.
Okay.
If you want some light humor, you can go to some of these websites, YouTube probably, and see what happens when judges are elected. This happens in America a lot. Fortunately, not for the senior judiciary, but actually, like politicians, they publish a manifesto and they campaign, they canvass, and say, I'm going to do this if I'm elected for a strict term, 5 years. And then they want to get re-elected. So they say, during my first term, I did this, this, and this. I'm going to improve on that, and I will do this, something else and something else, That is terrible, absolutely terrible. The other terrible thing, which also not as blatant as that, is I'm very concerned about quota system for judges. Please, if it ever comes to Malaysia, resist it. It is already there in an informal, unstated way. You know about it more than I do. But the idea that you have to have a minimum of X community, Y community, ethnicity, religion, background, sexuality, and these categories are increasing by the day. That is going to be very, very deleterious to judicial independence. So South Africa is a good example. It's already in existence.
Yeah, I don't think we have that sort of quota system. We do have, like, in terms of women being appointed as judges, so we don't have a problem. What if there is a country where there is a resistance to inclusion, of women, for example? Would that justify a quota system?
No. So actually, I have to slightly disagree with you, but conscious of the fact that I may be wrong and you're right. Okay, I'd be a little hesitant if this is going to be recorded and streamed and all that. But I do remember, as recently as 5 years ago, when Richard Mullingham was being made Chief Justice. Okay, there were some people, at least some people, who said he should not be. Okay, I don't want to tell you what the reasons were. You all know it better than I do. Okay, so it's not entirely true that such things don't happen in Malaysia or have not happened in Malaysia. Resistance to someone.
Okay.
But on the question of women, look, I have absolutely nothing against, for example, the entire Supreme Court or entire Federal Court being composed of women. No problem, as long as you go by merit. Look, once you open the floodgates of saying, because we have not had a female Chief Justice for so many years, we should now have a Chief Justice. Now, For example, what they did in Singapore is unbelievable, or was unbelievable, and they said the person who contested election for president, it shall be reserved for a Malay. Now, come on. In Singapore, for that to happen, whatever the other faults of Singapore, at least they used to go by merit. But once you make the breach, then it is going to lead to all kinds of problems.
Yeah. Okay. There is a question from one of our group member in the WhatsApp. He asked the question that he heard that you voice a negative aspect of the basic structure doctrine.
Yeah.
Could you elaborate a bit more on that?
By coincidence, I sometimes am asked to deliver full lectures on that topic, and I've just to add to the, I would call it fun, but it's actually not fun. I recently reviewed a book on this very topic, very subject, authored by a very competent, recently retired Supreme Court judge in India. And I was not exactly obliging in my review for other reasons. Anyway, I'm willing to say a few things about it. Look, how did the basic structure doctrine come about? It came about because there was a massive tussle between Parliament and the Supreme Court on the interpretation of the Constitution. And this was framed in very unfortunate terms by Mrs. Indira Gandhi, who was, as you know, one of probably the most populist prime minister in the country. She was arguing that the Constitution came in the way of social reform. And the only reason why India is suffering so much at that time was because a lot of rich people are unwilling to give up their privileges. A very, very bold statement. Okay, and therefore, let us nationalize banks, let us nationalize airlines, let us nationalize anything that is moving. She did it. Now, these were all challenged in the Supreme Court. And the Supreme Court at that time was quite not only independent, but also quite efficient. And a series of cases came up. Fascinating to read. If you're interested in constitutional law, the relationship between constitutional law and politics, fantastic resource material. And in most of the cases, the Supreme Court pointed out patiently, soberly, in good language, that it is not the Constitution that is coming in the way of social reform. It is just that politicians are playing a bad game, etc., etc. So the Supreme Court defended the principles of the Constitution. And the Supreme Court also, in one famous case, decided in 1973, it's called Keshwananda Bharati versus Union of India, said that, the corollary to this was Mrs. Gandhi then started amending the Constitution as soon as any judgment came from the court. So if the court says you can't nationalize something, she would immediately change the Constitution and say, now, what do you have to say? It became a tussle constantly. So the court said, okay, let us bring an end to all this. You can change whatever you want in the Constitution, but you cannot change the basic structure of the Constitution. In other words, there are certain things in the Constitution which cannot be altered. Now, the difficulty with that is they did it with very good intention. The difficulty is who is to determine what is basic structure and on what criteria. So now what has happened is the latest, I think, again, I may be out of date, had about 33 elements as basic structure. It just keeps expanding. So, secularism, independence of judiciary, those are all non-controversial ones. And then you add something else to it, and you said you can't touch them. So what is the basic structure Constitution? It has become what one academic described as a super constitution. It goes even above the Constitution. You can't touch these things. And the collegium system was incidentally justified on the basis of the basic structure doctrine, that we will not allow any say of anybody except judges in appointing other judges because of the basic structure doctrine. So in a nutshell, that is what the basic structure doctrine is. It is at one level outrageous, at another level farcical, but there we are.
And I think Malaysia Constitution have amended more than 200 times.
Right. So again, on a lighter note, my friend Gopal Sriram attempted to bring in the basic structure doctrine into Malaysia. I think he was rebuffed. he was in the Court of Appeal at the time, and I think the federal court rebuffed him. I haven't followed that debate as closely as I should.
Okay, I think we have two questions from the online participants. First one is from Liu Chiu Kiat. He asked, what will be the best suggested solutions or suggestions for the current situation in Malaysia? Second one, maybe I'll just read it out as well. Chan, if judges were taken off on high-profile cases which were not yet resolved, what are the chances there are government interference in these circumstances?
Okay, I haven't understood this second question. I'll ask you to explain it to me. On the first question, honestly, I have no answer. Unless the questioner thinks I'm God, there is no way I can answer that question. And it's just too difficult for me. So what is the second question?
I think the second question relates to, because our prime ministers, there are a few cases that's ongoing.
Yep.
So I think he is trying to ask if that will be seen as a interference in terms of the appointment of judges.
Okay, in other words, that you...
there will be a conflict.
There are various ways of doing it. One is to say that the new Chief Justice will not allow a panel consisting of judges who may be potentially hostile to the Prime Minister. That's one way of looking at it. The other would be to say that the Chief Justice, the person selected, may constitute a bench that would be sympathetic to the Prime Minister.
Yeah.
There are various possibilities. I don't know enough about the details of these cases. So in theory, yes, of course, that is actually one of the reasons why people want a judiciary that is free of these possible potential troubles. Now, again, if you want a twist to all this, there are so many of these things that happen on a day-to-day basis in India. They have also given the Chief Justice a new title, which is the Master of the Roster. Okay, now that means the Chief Justice can decide at his sole discretion who is going to sit on what panel. And there, because the Supreme Court is 34 judges, you will have at least 15 panels at any given time. So wide room for bias.
Yeah, I think the perception is that because the current Prime Minister have filed applications to the court, constitutionally said that he is immune from any legal proceeding, even the case was filed before he became a Prime Minister. And this is a constitutional challenge now in the federal court. So the Chief Justice that has been appointed through the Prime Minister recommendations will be sitting on
this panel.
Right? And he's the Chief Justice. So
yeah.
So the connections I think people have is that this is political in
Absolutely.
nature.
There's good reason for it. But sometimes, very occasionally, people will be stunned to see that someone who was seen as so beholden to the Prime Minister has become very independent as soon as he's appointed or shortly after he's appointed. That also happens in some cases, but you can't take a chance.
Yeah. Yes. Is there any other questions or no questions? I think Malaysia is also looking at how we can, improve the JSC, how we can strengthen this appointment process after this whole saga. So, of course, we are trying to see other countries in comparisons. What are the best model? Open, confirmations, whether we want transparency. But I think you mentioned something about judicial accountability. Yeah, perhaps you can enlighten us a little bit more about what.
Yes, that is again a topic which has so many dimensions because there is institutional accountability, there's individual accountability. I think I once actually, rather bravely or foolishly, gave a lecture on that issue to the entire Malaysian judiciary. All the senior judges turned up. They had some sort of a conference. This was under I think it was Arifin who was the Chief Justice at the time.
Mm.
Accountability is very, very important,
Yeah.
because once you appoint a judge, they are appointed for life. I mean, subject to retirement ages, and they can actually go out of control in a bad way, even if they're not otherwise, not necessarily because they're politically beholden to someone, but just personal misbehavior. And it's how difficult it is to impeach a judge. So there is that is the sort of thing I was talking about. And of course, also accountability in terms of competence, because if somebody is wrongly appointed, they are there for 10 years, 15 years on the bench, and judicial administration suffers just because of their lack of intelligence.
Yeah.
On a facetious note, if you're going to end, I would say, who knows, in a few years, artificial intelligence will probably remove many of these problems.
That is something for us to ponder, really. But I think it's really important, as you say, the judicial competence, because I'm practicing as well. I really get what you're saying. And that is exactly why the judicial appointment process from the beginning has to be correct, has to be right. The criteria, the selections, the appointment, even the transfer, the elevation of judges, all this has to be right. And I think we are at the point where we are trying to find what is the best way for us to, have this thing more tightened up, because this thing the recent incidents really make us realize that we actually have gone back to the previous era where we don't have the JSC, and the Prime Minister is the one that is controlling everything.
Since no one is asking
I think you need this.
Thank you, Thomas. Venkat, I want to go back to the questions of your objections against public hearing.
Against what?
Public hearing
Oh,
in,
yes.
in judge appointment.
Yeah.
I mean, in the presidential system, because it's built on check and balance between two elected branches, therefore it has to be so. I can see the potential harms of having public hearing. One is that it become a populist contest in towards the directions of like elected judges in America and now in Mexico. The other part is, of course, that public hearing can be inhibitive for candidates who want to take up high position. They may not want to get their whole life being examined before the publics. But not having public hearing, we might eventually end up just putting another layer that cannot prevent a majoritarian control of the system. As in my first question just now, I think ultimately there cannot be a perfect system. Is which imperfection that we need the most. So weighing against different imperfection, which is the most. So at this stage of our time, what do you think as the main threat to the system? Could it be because of, let's say, if you have pardon my comparison to Catholic Church, right? A judge appoint judges system that could result in cronyisms and mediocrity and so on, or ones that some other higher unelected institution making all the decision and they are unelected, so therefore you cannot hold them to any account at all. Thirdly, that you could be a prime minister that actually control everything, and further, given that the disguise that he's actually he can be held accountable by the voters. Or fourthly, you partisan politics that may undermine the whole process. Out of these four, which one do you think is the biggest threat in our consideration? So I'm putting it like all are bad, which is worse?
It brings me back to what I frequently say. We are looking at the least worst option. And I'm not even sure if those are the four criteria we need to look at. In very broad terms, I would actually simplify it by saying this, that, you know, the two things we need to look at in a judge more than anything else would be integrity and competence, broadly speaking. Of course, you could add to it things like good health and all that, because what use is a judge who is chronically ill? Normally, that doesn't, then you begin to go down a route which is undesirable of giving judges a fitness test, health fitness test. So, otherwise, integrity and competence. So, I believe, as I said earlier, that this is not a plea to go back to the old system, but I'm just telling you that the old system has its virtues, in that both competence and integrity would be judged very thoroughly by these soundings. Soundings don't look like a good word before the tap on the shoulder, because at the bar, it's very easy for a person's bad habits to be detected, and word spreads very quickly if you're not a man of character. And competence as well. You perform badly in court, one or two cases, and word spreads very quickly. And that, I think, is a safeguard against appointment of wrong people. I'm not saying it's a foolproof way, but in the end, I'm persuaded that that system probably works. But again, that also requires the appointing people or the selecting people to be good. If they themselves are corrupt, what do? So we are all humans. This is the difficulty. That's why I said artificial intelligence probably the only way. Even that, of course, won't work. All I'm saying is, if humans are bad, there is no hope, whichever way you look at it. You can put in a few checks and balances or safeguards, but I don't know in the end if making the system over bureaucratic is the solution.
Yeah, I think the JAC, the composition of the JAC is so important. And you said the integrity, the people in the fraternity will know about these persons, how they behave in court. But in Malaysia, the JAC composition does not include the Bar Council.
There you are.
Malaysian Bar,
absolutely.
right?
Yeah.
So maybe we should start from there.
Yeah.
But again, the problem will be the recommendations eventually that come may not be adopted by the government.
Absolutely.
And,
Yeah.
So it goes back to the same cycle again. Yeah. Okay. Is there any question? If no more, I think we really have heard a lot from you, and we really learned a lot. I think there's some MP's assistants here today, right? Are they? Yeah. So hopefully we can bring this back to the respective elected representatives who are really keen on this reform, and we are really happy to continue to contribute to the conversations if necessary. And thank you very much. Thank you, Dr.
That the last point you made is quite practically useful and important. If you're able to get MPs and not the civil society people, but also other potential constituencies who may be involved in judicial appointments together, if necessary, in a closed room, not a public forum, that can help a lot, because I think to some extent MPs need to be better informed. And sometimes you may have decent people of integrity among MPs who may not be as well informed about these things as they should be. And therefore, any sort of education session, you won't call it that, but some sort of a dialogue within closed doors would probably be helpful. And of course, you can also get a few retired judges to be part of that. They will give you all kinds of stories. My God, that will actually tell you what is actually happening in the judiciary.
Yeah, absolutely. Thank you for the suggestions. We will definitely work towards that. So that will wraps up today's public lectures and forum. Thank you everyone for coming here. I mean, if you guys don't mind taking pictures, maybe we can all come together for a group picture.
Easily, all of us, yeah.
Can everyone come? Yeah. Round of applause for Venkat, sorry. Yeah.
Right. So stand there.
Yeah.
Okay.